My dear friends, I am Dr. Waseem I Khan, Assistant Professor, Shri Shivaji Law College, Parbhani, Maharashtra, India. So in today's lecture, we will discuss the very important topic of law of tort, and it comes under the tort of negligence, that is res ipsa loquitur. The thing speaks for itself. So we will cover this particular topic in this lecture. So let's start the topic. Res ipsa loquitur we will discuss in this lecture. In the previous lecture we have discussed the essentials of negligence, in which we have discussed that if a person is having a duty to take care, and if the care is not taken, it results a damage to someone else, the person will be liable for the tort of negligence. Now we will move towards the principle of res ipsa loquitur, which is a part and parcel of tort of negligence. It means proof of negligence, the thing speaks for itself. Sometimes the thing speaks for itself. If we narrate the story itself says whose negligent act is there, and under such circumstances only principle of res ipsa loquitur will be applicable. The principle of res ipsa loquitur shift burden of proof from plaintiff to defendant. Normally and generally, we knows very well the burden of proof always on the plaintiff. Plaintiff has to prove the negligent act of the defendant, then only he will get a compensation, otherwise not. But there is a situation, if the situation of res ipsa loquitur is there, then burden of proof shift from the plaintiff to the defendant. Now defendant has to prove that his negligent act is not there. So res ipsa loquitur shift a burden of proof from plaintiff to defendant. According to Lord Shaw, sometimes a thing tells its own story. Lord Shaw says that sometimes the things tell its own story. If we narrate the story itself indicate that it is the negligent act of the defendant. There is no need to prove the essential of negligence. The facts and circumstances which the plaintiff has proved establish a prima facie case of negligence against the defendant. If the plaintiff narrate the fact and circumstances of the case, it is sufficient to prove and establish a prima facie case against the defendant. If only fact and circumstances which is narrated by the plaintiff, it is sufficient to establish a prima facie case of negligence against the defendant if the case is relating to a res ipsa loquitur. These are the two cases in which the principle of res ipsa loquitur was applied by the court. Byron versus Bordell. In this particular case, the plaintiff, while going across the road, a floor barrel fell down on the plaintiff from the window of the defendant, and plaintiff got injured. Plaintiff filed a suit against the defendant, and if I narrate the story, plaintiff was going through the road, the floor barrel fell down on the plaintiff from the window of the defendant. This particular story indicates that it is the negligent act of the defendant because the floor barrel fell down from the window of the defendant itself. So that's why in this case the court applied the principle of res ipsa loquitur and held liable to the defendant because the floor barrel fell down from the window of defendant. This is the case in which the principle of res ipsa loquitur was applied by the court. Mahendranath versus Mathurdas. In this particular case, the cinema board was tied in the premises of the defendant, and when the plaintiff was in the premises of the defendant, that cinema board fell down on the plaintiff and plaintiff got injured. Now the premises belongs to the defendant, the cinema boards belongs to the defendant, and that due to the cinema board the plaintiff sustained a loss. This story indicates that this is the negligent act of the defendant, and in this case also the court applied the principle of res ipsa loquitur and held liable to the defendant. Now we will move towards the essential of res ipsa loquitur when court will apply the principle of res ipsa loquitur. The first essential of res ipsa loquitur is exclusive control and management of the defendant. Whatever the thing due to which the plaintiff sustained an injury, that thing must be under the exclusive control and management of defendant. The thing causing the damage must be under the control of the defendant or his servant. So in the two cases which we have discussed, Bahrain versus Bodel, in that particular case, the floor barrel was under exclusive control and management of the defendant. And due to the floor barrel, the plaintiff sustained an injury. So whatever the thing by which the plaintiff sustained an injury, that thing must be under exclusive control and management of the defendant. In the cinema board's case, the cinema board was under exclusive control and management of the defendant. So this is the first essential of res ipsa loquitur. Now the second essential is that accident must be such as would not happen without negligence. For applicability of principle of res ipsa loquitur, the accident must be such as would not happen without negligence. If the act of the defendant was not a negligent, the accident would not happen. So why accident happened? Because defendant was negligent. In the Bahrain versus Bodel, if the defendant took the proper care and if he put the floor barrel at some other place, then definitely the accident would not happen. So why accident happened? Because the defendant was negligent. He put that particular barrel on the side of window, and that's why the plaintiff sustained an injury. So accident must be such as would not happen without negligence. Now there is one case which explains the second essential, or in which the principle of res ipsa loquitur was applied. Municipal Corporation of Delhi versus Shubhangavati. In this particular case, there was a clock tower on Chandni Chowk, Delhi, and the normal life of that particular clock tower was 40 years, and 42 to 45 years has already been elapsed, and the municipality fails to dismantle and demolish that particular clock tower. And one day a clock tower collapsed and several person dies and several person got injured. The suit has been filed against the Municipal Corporation of Delhi, and in this case it is my question whether the principle of res ipsa loquitur will be applied or not. The first essential, the things must be under exclusive control and management of the defendant. In this particular case, the clock tower was under exclusive control and management of Municipal Corporation of Delhi. The first essential has been proved. The second essential is that accident must be such as would not happen without negligence. In this particular case, if after 40 years, if the municipality demolish the clock tower, then accident would not happen. In this case, the second essential has already been proved, and the court applied the principle of res ipsa loquitur in this particular case and held liable to the defendant, that is Municipal Corporation of Delhi. Another case, Skinner versus London and South Coast Railway Company. In this particular case, two trains belonging to defendant company collided each other, and a plaintiff who was passenger injured. Two trains belonging to the defendant's company collided each other. They runs on the same track and there was a collision. These two trains was under exclusive control and management of the defendant company, and if the defendant company would have taken a proper care, the accident would not happen. It means in this case also the court applied the principle of res ipsa loquitur and held liable to the defendant. So second essential, accident must be such as would not happen without negligence. And the third essential is that no explanation by the defendant. The maxim will not apply if the defendant can explain the happening of the accident. If the defendant is having a certain explanation, then maxim of res ipsa loquitur will not apply. In all the cases which we have discussed, there was no explanation for the defendant. In the clock tower case, there was no explanation with the municipality. Municipality cannot explain the accident. In the Bahrain versus Bodel case, defendant cannot explain his negligent act. So if there is explanation, maxim will not be applicable. If there is no explanation, then only principle of res ipsa loquitur will be applicable. So in short, we can say that principle of res ipsa loquitur means the thing speaks for itself. If you narrate the story itself says that it is the negligent act of the defendant. So this is the res ipsa loquitur. I hope you understand this topic. If you understand this topic, please subscribe my channel, hit the notification button, hit the like button, and share this video with your friends. Thank you very much.